Yeah, joinder of charge. Hello? Yeah. Joinder of charges. So, according to section 241, for every distinct offense for which the person is accused, please underline, every distinct offense for which a person is accused, there will be a separate charge, and every such charge shall be tried separately. Provided that where the accused person by application in writing desires and the magistrate is of the opinion that the person is not likely to be prejudiced thereby, the magistrate can try together all or number of charges framed against that person. So nothing in this subsection shall affect the operation of section 242, 243, 244 and 246. So for every charge, for example, the charge is framed under section 302, 303, then for murder, for dacoity, for theft. So all these charges will be tried separately. Okay, all this, because all these have different offenses, all these have different punishment, so they must be tried separately. But if the accused is of the opinion that no, he must be tried together, and if the magistrate is also satisfied that yes, it can be tried together, then these offenses can be joined together. That is known as joinder of charge. Now section 242. So where a person is accused of more offenses than one of the same kind committed within the space of 12 months, please underline the word 12 months, from the first to the last of such offense, whether in respect of the same person or not. So whether in respect of the same person or not, it may be different person also. Okay, for example, first I am committing offense against you, second I am committing offense against another person, but it is within the space of 12 months, within the duration of 12 months, within the duration of 1 year. Okay, he may be charged with or tried with one trial, and any number of them exceeding 5. Offenses are of same kind when they are punishable with the same amount of punishment under BNSS or any law. For example, for most of the trial cases, when we see it is less serious offenses, it is punishable for a period of 2 years. So if you have committed offenses that are punishable with 2 years and there are so many offenses, then you can be tried together of all the offenses. Now section 243. So if in one series of acts so connected together as to form the same transaction, more than one offense are committed by the same person, then he may be charged with and tried with one trial for the every such offense. Please underline the word one trial. So when a person is charged with one or more offense of criminal breach of trust or dishonest misappropriation of property as provided under section 233 and 242, is accused of committing for the purpose of facilitating, please underline the word, for the purpose of facilitating and concealing the commission of that offense, one or more of the falsification of account, then he may be charged and tried at one trial. Please underline. He may be charged and tried at one trial for every such offense. Now 244. So if a single act or series of acts is of such a nature that it is doubtful which of the several offenses the fact must be proved will constitute, the accused may be charged of having committed of all the offense, and any number of such charge may be tried at once. So if there is a single act or a series of acts and of such a nature that there is doubtful which of the several for example, see, if you conduct joint trial, then everything will be going simultaneously, evidence, recording, everything. So in that case, it is little doubtful which of the several charges must be tried so that the accused person is finally given punishment. So it is provided under this section. Now section 245. So when a person is charged of an offence consisting several particulars, for example a combination of some only which constitutes a complete minor offence, and the combination is proved but the remaining particulars are not proved, then he may only be convicted of that minor offence though he was not charged with it. Okay. When a person is charged with an offence and fact is proved which reduce it to minor offence, then he may be convicted of minor offence although he was not charged for it. When a person is charged for an offence, he may be convicted or attempt to commit such offence although he did not attempt, is not separately charged. For example, I will tell you there are two categories of offences under BNS. For example, when you cause hurt and when you cause grievous hurt. For example, if the section of grievous hurt has been framed under the charge, but during the trial and by adducing evidences it was found that it was not a grievous hurt, it was a normal hurt. Because see, when you tell grievous hurt, there are 6 categories of grievous hurt that is provided under BNS. You cannot go outside that. Okay. So the court found that it is not grievous hurt but it is a normal hurt. So in that case the punishment can be reduced, a reduced form of punishment may be provided. That is also a minor offence. Hurt is a minor offence. Okay. Next, 246. The following person may be charged and tried together, namely, a person accused of same offence committed in the course of same transaction, a person accused of an offence and the person accused of abatement or attempting or helping. All this will be tried together. Even if you have not committed the offence, you have abated the offence, you have attempted the offence, so the punishment will be same. Person accused of more than one offence of the same kind within the meaning of 242 committed by them jointly within the period of 12 months. Then person accused of different offences committed in the course of same transaction. Okay. Now 247. So when a charge containing more than one is framed against same person, and when a conviction has had on one or more of them, the complainant or the officer conducting the prosecution may, with the consent of the court, withdraw the remaining charge or charges, and such withdrawal shall have an effect of acquittal of those charges. So for example, if I am blaming on some person that you have committed murder 307, but after that I am withdrawing those charge, then the court will presume that withdrawal of the remaining charge means that I have been acquitted on the same charge, unless the conviction be set aside in the case. The said court may proceed with the inquiry into the trial of the charge and the trial so withdrawn. Now in the case of K. Sawan Singh versus State of Punjab, All India 1960, Supreme Court 266, that the section of Joinder of Charges are not compelling in nature. They only permit joint trial of charges under certain circumstances, and the court may consider the same in the interest of administration of justice after thoroughly studying the facts and circumstances of each case.